I read your submission, and it just really repeats what the Act does. And it says that if the boxes are opened prematurely, that the votes in the boxes are to be excluded from scrutiny. Now, the point I'm going to make is this, that if you have someone who's unscrupulous and has access to boxes of votes, and they know where a box of votes is coming from, and they know that that particular polling place could be advantageous to a particular candidate, and we're in a marginal seat, by opening that box, you could knock out all those votes and totally change the outcome of the election. It is not unknown. In past elections, I've actually been involved in being with police pursuing ballot boxes being taken to police lockup because we were afraid of tampering with the ballot boxes. So you cannot say that it won't happen. So it's, to my way of thinking, by saying that the votes will be excluded, actually encourages people to tamper with boxes. So what we're discussing now is the proposition that there be placed into the law that if boxes are tampered with, those votes are excluded. That actually encourages someone, if they wish to act in a dishonest way, to in fact tamper with the box and have those votes not counted, which can change the outcome of that seat and of an election. So we're not clarifying the law, we're not making it better, we're making it worse. And I'd like to hear what you have to say about that, because I'm disappointed you didn't address the point in your submission.
The point about, sorry, Mrs Bishop.
The fact that it lays it open to somebody with mal intent to tamper with a box to change the outcome of the election.
Well, it was something that we just didn't consider as a possibility.
But that's so often the case with the Australian Electoral Commission,
Mrs Bishop,
I would have more confidence in them and the DRO having been able to make a decision that this was done with no evidence of tampering and therefore the vote should be counted, than I would finding any old box that had been tampered with and say, oh, well, that one's out, because the law says so, because anyone could get to those boxes and do it with malice aforethought. And I am reminded of the sudden pile of votes that appeared when Cheryl Curnow got elected in the seat in 2007.
What a complete load of codswallop. I mean, it was a
Suppose
close
you're
vote.
concerned-
She got over the line.
So
Mrs
what
Bishop,
is the
there's
matter?
not much more I can add.
Not is.
It's
What
not
is
much.
the matter with having the DRO having the discretion to make that decision, and then you having the power, if you're not satisfied, to going to the Court of Disputed Returns? What is the matter with that?
And I would have thought...
And I'll tell it to you. The Court of Disputed Returns in McEwen, where the returning officer had an interpretation in relation to votes, which a lot more votes were included, and where you escaped in relation to that matter was it applied to both sides. The interpretation was across the board, but his interpretation was out of kilter with the rest of the Commission. There's a perfect example of where discretion can lead you into a dangerous area.
So help me, every election, in every polling place, those of us who are scrutineers go through that situation all the time.
This is
we
different.
say no to this ballot paper, yes to that ballot paper, and ultimately the DRO makes a decision.
Am I right
If
or
you
wrong?
don't like the decision, and there are enough of them, then you can go to the Court of Disputed Returns. That's exactly what happened there. What we're saying here is that voters are going to be disenfranchised because someone got to the ballot box. And therefore, they're not allowed to have their votes counted at all. And that's an outrageous proposition.
I think, and I don't mean to put words in my colleague's mouth, Mrs Bishop is concerned that this proposed provision contains no flexibility whatever. Now, we haven't, as far as I know, had instances of this, but you draft electoral laws in particular to try and account for as many circumstances as possible. Let's say, why would it be inappropriate, for example, for if there was either a witness of an official to someone running in and snipping the tags or somehow tampering with the ballot box, so that it was in plain sight, but someone has run in and just done something to the ballot box and ripped the tags off, and so there was no concern with multiple witnesses from the Commission that there had been tampering with ballots, but the box seals have been broken and therefore triggering this provision. Or if, for example, polling booth at the airport where there are security cameras covering basically every square inch, they could realise pretty quickly that someone just walked in and in the place of putting their ballot paper in the ballot box decided to tamper with the box. What I think would concern me here is that if there was overwhelming evidence that the ballot papers hadn't been tampered with to the satisfaction of Commission officials or to the Commissioner, and that someone had tampered with the box and the seals, that this provision actually would knock out votes over which there really is no doubt. And that I don't agree with the scenario the chairman put. There are multiple scenarios possible here, including people just tampering with the box and not with the ballot papers. So why wouldn't a provision that gave either the DRO or the Commissioner more flexibility? Because why would we want to come back here and say, yeah, we know someone ran in, they tampered with the ballot box, we lost 400 votes, regardless of whether or not they change the outcome? I mean, they might change the outcome in a small state for the Senate, if not a lower house seat.
And also, can I ask, what is the penalty for deliberately tampering with a ballot box?
It'd be the $1,000 fine.
Is it 6 months in jail as well?
No.
So $1,000. That's it.
Is David Phillips from Family Voice on the line?
Yes, you do.
And Mr. Stephen Leslie?
Yes, that's correct.
Okay. Can I just get you to both formally give us the names and capacity in which you appear? First, Family Voice.
My name is David Michael Phillips. I am National President of Family Voice Australia.
And the Electoral Reform Australia.
And I'm Stephen Leslie. I'm the Vice President of Electoral Reform Australia, which is the New South Wales branch of the Proportional Representation Society.
Okay. Can I thank you each for the submission that you've made to the inquiry?
But we are concerned with the proposal to exclude votes that from ballot boxes were opened prematurely. We believe it's a fundamental right of citizens to have their vote counted, and we think that the measures proposed are excessive and heavy-handed. We would prefer to see that the discretion given to the district returning officers to assess the problem and to address it in a manner that enables as many votes to be included into the ballot paper as possible. But by excluding votes, you're enabling such actions to be benefited from the perpetrators.
I'll ask either of you, if you're going to allow discretion in the polling officials, have you got any views about the guidelines to be drawn up in relation to those polling officials and the exercise of their discretion? I mean,
yes.
What's the basis upon which one might say the votes are in, or one might say the votes are out?
If the votes, the polling box has been opened because of poor administrative procedures, as soon as the district returning officer is made aware of this, he should advise the scrutineers present of such matters, get a report and assess it accordingly. This is when the branch, the officer in charge, notices these things, and the district returning officer is the one who would make these decisions. And you make the decisions having informed everybody involved of what has happened. Now, of course, many of these things might be just very minor things. So a polling clerk, for example, opening a box to get someone's car keys out. But it would be unreasonable under those circumstances to exclude the entire ballot box. There might be 1,000 votes in there.
Yep. David Phillips here from Family Voice.
Thank you.
We too would not want it set rigidly in law, because if you say that any box that's been tampered with is automatically excluded, then that provides an opportunity for some miscreant to exploit that situation and deliberately tamper with a box of votes that the person considers might favour their objective. I think it's much better to have discretion, probably initially in the hands of the Divisional Returning Officer or the Electoral Commission, but appellable to the Court of Disputed Returns if there is, and so that nobody knows in advance, a surefire way of manipulating the voting process. But if an error occurs, then it is addressed by the appropriate officials or a court challenge, which in the action to the Court of Disputed Returns would presumably only occur if the election was so close that the ballot box in question would or potentially could make a significant difference to the outcome.
Thank you very much, Mr. Phillips and Mr. Leslie. I'm sorry you weren't here earlier because I was arguing precisely your point of view. It has prompted me to think of one further thing, and that is that this legislation merely says that a box that has been tampered with, the votes shall be excluded from the scrutiny. There is absolutely no provision that I can see, and perhaps someone will correct me if I'm wrong, about what would happen to those ballot papers, whether they should be counted after the event to see if it would have made a difference to the outcome of the election, and whether or not the Electoral Commission should be obliged then to try and go to the Court of Disputed Returns. But the problem is, if the Act simply says they're to be excluded, then there is no basis for going to the Court of Disputed Returns. So it does, even further to what you say, and you might comment on this, mean that you can have very unhappy outcomes where people can say, well, if those votes were counted, I would have won, but nobody will ever know because there's no provision for what happens to those votes.
This is an example where certainty is bad because certainty opens an opportunity for fraud. If someone with malicious intent knows that the votes from a particular booth are likely to favour the candidate they don't want, they can tamper with the box and have them excluded. So certainty opens an opportunity for fraud. If you allow it to the judgment of either the DRO or the Court of Disputed Returns, then that does not open up a surefire method for fraud.
What this provision says is that if the box is tampered with, then the votes are excluded from scrutiny. And that's an end to it. It's not a question whether the scrutiny determined it one way or the other. It is not scrutinised.
Rather than talking about excluding the votes, would it be better to, if the bill talked about preserving the votes, which could then be subjected to scrutiny and the numbers of votes for the different candidates known, and whether they are actually applied to the outcome could then be determined as a matter of judgment.
The long and the short of it is that Senator Ryan made the very excellent point earlier that people who initiate or go to the Court of Disputed Returns are people who are candidates or political parties or the AEC. None of those people are concerned with the question of the franchise, the right to cast your vote. And these people, by this provision, are being disenfranchised. Because of the act of a third party, those people's votes are not counted.
Mr. Phillips,
and that's a very different proposition.
Mr. Leslie, I just want to pursue this presumption of inclusion.
Yes.
What are you saying? The presumption should be for inclusion,
yes,
with
we
then
think that should be included.
With then an opportunity to exclude on a particular basis.
Well, we think that a prematurely open ballot should be resealed, kept separate and not counted. A report outlining the details should be submitted by the booth returning officer to the district returning officer for his or her consideration. Party scrutineers should be asked to, if they wish to, submit supplementary reports, and if they do, these should be included with any report to the district returning officer.